Can anyone file a defamation suit claiming 10 crore rupees, 100 crore rupees, or even 1000 crore rupees? Does the court first verify whether such a huge claim is actually justified? Can a powerful person use a defamation case simply to pressure a political opponent, a journalist, a YouTuber, or a social activist? And if these cases ultimately end in an apology or settlement, why do they continue to consume years of valuable judicial time? These are important legal questions that deserve serious discussion, not from a political perspective, but from the standpoint of law and justice. In today's video, we will examine: what exactly is a defamation suit? How does Indian law deal with such cases? Why are claims running into hundreds of crores becoming increasingly common? What have the courts actually decided in some of the most high-profile cases? And finally, should India consider legal reforms to prevent the misuse of defamation litigation while fully protecting every citizen's right to reputation? I'm happy to share that our channel has crossed 1 lakh subscribers and received the YouTube Silver Creator Award. Thank you for your continued trust and support. For more legal awareness videos, subscribe free of cost. If you'd like to support the channel, you can become a member for 59 rupees or 119 rupees by scanning the GPay QR code on the screen. Now let us move towards today's main topic. What is defamation? Under Indian law, every individual has a valuable legal right to protect his or her reputation. If someone makes a false statement that harms another person's reputation, the aggrieved person may seek legal remedies. Broadly speaking, Indian law provides 2 remedies. The first is civil defamation, where the person seeks monetary compensation for the alleged injury to reputation. The second is criminal defamation, where criminal proceedings may be initiated in accordance with the applicable law. Both remedies continue to exist under Indian law, and in appropriate cases, both may be pursued simultaneously. So, filing a defamation case is not unusual. It is a recognized legal remedy. However, an important question arises. Can this legal remedy itself sometimes be misused? That is where today's discussion begins. Why are such huge claims being filed? In recent years, we have repeatedly seen civil defamation suits claiming damages of 10 crore rupees, 100 crore rupees, or even more. Naturally, many people ask, can anyone simply write any amount in the plaint and approach the court? The answer is not as simple as it appears. A plaintiff may quantify the damages claimed in the suit. However, merely claiming a particular amount does not mean that the court will automatically award it. The plaintiff must ultimately prove, through evidence, that the alleged injury to reputation actually justifies the compensation claimed. In law, claiming damages and proving damages are 2 very different things. What does the court examine first? Many people believe that the court immediately verifies whether the plaintiff has actually suffered damages worth hundreds of crores. That is not how civil litigation generally works. At the initial stage, the court ordinarily examines whether the plaintiff discloses a valid cause of action, the court has jurisdiction, the suit is filed within limitation, the valuation and court fee comply with the applicable law, and whether the procedural requirements under the Code of Civil Procedure have been satisfied. However, the actual extent of reputational loss and the quantum of damages are usually determined only after evidence is recorded during the trial. Therefore, a high-value claim may be filed at the beginning, but whether that amount is legally recoverable is decided much later. What about court fees? Another common question is whether filing such large claims is expensive. The answer depends upon the state where the suit is filed. India does not have one uniform system of court fees. Different states follow different court fees laws. In some states, court fees may be comparatively modest, while in others they depend upon the valuation of the claim. Therefore, there is no single nationwide rule. Nevertheless, legal experts have often suggested that exceptionally large claims should perhaps receive greater judicial scrutiny at the preliminary stage. Some well-known examples. Let us now look at a few important cases. Former Union Finance Minister Arun Jaitley filed a civil defamation suit claiming damages of 10 crore rupees against Arvind Kejriwal and others. The litigation continued for a considerable period. Eventually, written apologies were submitted, and the suit was withdrawn. Interestingly, despite the claim of 10 crore rupees, no court awarded damages after a full trial. Another example involves Union Minister Nitin Gadkari. He initiated criminal defamation proceedings against Arvind Kejriwal. The matter also concluded after an unconditional written apology, and the complaint was withdrawn. These examples demonstrate that several high-profile defamation disputes eventually conclude through apologies or settlements rather than lengthy judicial determinations awarding massive compensation. There is also the well-known Rahul Gandhi, Modi surname case. This was not a civil damages suit but a criminal defamation prosecution. The case generated nationwide debate regarding freedom of speech, political criticism, and the protection of individual reputation. What has the Supreme Court said? The Supreme Court has repeatedly recognized that reputation forms an integral part of the right to life under Article 21 of the Constitution. At the same time, freedom of speech and expression under Article 19, 1a, is also one of the most important constitutional freedoms. Therefore, neither reputation nor free speech is absolute. The law attempts to strike a careful constitutional balance between these two competing rights. This balance becomes particularly significant when public figures and political criticism are involved. Should the law be reformed? Should the law be performed? This brings us to the most important part of today's discussion. Nobody disputes that every individual should have the right to approach the court if his or her reputation has genuinely been harmed. However, an equally important concern is whether judicial processes should be used merely as instruments of pressure or intimidation. Some legal scholars have suggested reforms such as greater preliminary judicial scrutiny in exceptionally high-value claims, requiring plaintiffs to disclose a reasonable basis for claiming enormous damages, imposing realistic costs where litigation is found to be frivolous, encouraging mediation before lengthy trials begin, and studying international practices such as anti-SLAPP legislation, which exists in several jurisdictions to discourage lawsuits primarily intended to silence public participation. These are policy questions that deserve thoughtful discussion by Parliament, the Law Commission, and the judiciary. Conclusion. The right to reputation is fundamental. Freedom of speech is equally fundamental. A mature constitutional democracy must protect both. The objective should never be to discourage genuine defamation cases. At the same time, the legal system should ensure that litigation is not misused to burden opponents, suppress legitimate criticism, or unnecessarily consume precious judicial time. The challenge is to achieve the correct constitutional balance. What do you think? Should India introduce stronger safeguards against the misuse of high-value defamation litigation while fully protecting every citizen's right to reputation? Thank you for watching this video. If you found this information useful, please like the video, subscribe free of cost, and share your views in the comments. For more legal insights, do not forget to press the bell icon. I shall meet you again soon in the next video. Jai Hind! Jai Bharat!